In this lecture, we would like to go back to jurisprudence and, in particular, historical jurisprudence, the very father of historical jurisprudence is Frederick Karl von Savigny, who was a professor of law at University of Berlin and also the Prussian Minister of Justice. And when he died in 1861, just before 1 year of his death, Charles Darwin published his monumental work, The Origin of Species. That's why Karl von Savigny is considered as the Darwinist before Darwin for his discovery of the theory of evolution of law. So, as regarding the very evolution of law, what he described that in his monumental work, that is vocation, Savigny strongly and persistently attacked and condemned the natural law school. Also, Thibaut's proposal on codification of Germanic law on the background of Napoleonic code. So, to Savigny, law is, in essence, is like society, its language, literature, grammar, folk music, folk culture, etc. Law with spontaneity through internal development evolves and changes in the same fashion and direction as society evolves. Hence, the law of any particular society is the embodiment and reflection of the spirit of a people united by common language, custom, feelings, and common past, who evolve and procreate law. Thus, the growth and evolution of law has no dependence upon individual, arbitrary will or accident. Law begotten in the people's work or by popular spirit, which is he named as Boggist. Law has its source, existence, and validity according to Savigny in the popular consciousness and inner feelings, and its customary observance is not the cause of law but the evidence of its existence. Law did not make its past appearance in the form of logical rules. It existed within each society and evolved by manifesting its appearance in the form of customs and traditions. So he outrightly rejected the theory of analytical patriotism or legal patriotism as developed by Bentham and enriched by his disciple John Austin in England. So, according to Savigny, the core element of his thesis is expounded by, as in his vocation, where he observes like language the constitution and manners of a people lay is conditioned and determined by the popular character of the people, by its national spirit, which he called as Boggist. and all the important elements of Savigny was summed up by Professor Friedman in his legal theory, which was edited the fifth time in 1967, where he summed up all the features of Savigny's historical school of jurisprudence as law is discovered, law is organic and developmental, law is sui generis. So, according to Professor Friedman in his legal theory, law is discovered or found and cannot be artificially invented or made. Secondly, law is fundamentally organic and developmental in character, which can be found both in primitive and modern communities in varying forms of popular consciousness and beliefs, customs and traditions, habits and practices which finally contribute to people's law or Bhogist. And the third feature that Friedman summed up on savings Bhogist is law is sui generis, peculiar to a people like its language and heritage, a manifestation of its national ego or spirit, so law cannot be of universal validity. So, in that way, according to Savigny, the he discovered that the very doctrine of continuity of law, so its emanation from people's spirit and founded on community's tradition, its roots in the hearts of the people, and it is like language. So Savigny considered law as an emanation of people's spirit, Bhogist, which is said to be of undying and continuing nature. Law, accordingly, like the community, has an unbreakable continuity and its present is founded on tradition. Law, therefore, cannot be superimposed or implanted from an alien source or foreign origin. Law has its historic root embodied in the hearts of the people. Law being a gist of the people acquires continuity even after its codification by the jurist, who, having sufficient knowledge and experience of history and culture, incorporate and transmit tradition and customs in the texture and rubric of national legal system. Like language, law also lives and flourishes with the community in an abiding and continuing fashion, and dies only when community loses its vitality and existence. Further Savigny envisages the doctrine of continuity to counter codification move, for he said a code destroys continuity in a growing legal system. So Savigny tried to nationalize the very spirit of the people, so interpreted law in mystical sense as the spirit of the people, while advocating national outlook and racial character of law, he took inspiration not from original German law but from the Roman law, which had been received in Germany during 6th century AD. For Savigny, the mixture of German law and Roman law could provide an excellent base for juristic development of a unified system. So, Savigny's idea of national law or people's law or popular spirit or vogue gist, as he emphasized by mixing the German law with Roman law, he made a mistake of explaining his theory of law as national spirit or popular spirit by combining Roman law with German law. So, also, Vogist or Savigny's popular spirit or people's will perverted into different forms. So, Savigny's theory of Vogist has been perverted by Nazi into a biological doctrine of pure and superior race to control the so-called biological inferior races, to preserve German racial superiority, and to achieve political and ideological objectives of German domination of the world by Hitler. He, as a dictator, used the gist or the vogue into an idea of superior race, a part of heredity by which Hitler enacted outrageous laws against non-Germans. So also, Savigny's vogue gist took the form of apartheid in South Africa. So, South Africa is in defense of the world public opinion was following racial segregation policies. And another aspect of this perversion is in modern times is the dangerous fundamentalistic doctrine based on narrow sectarian religion, leading to discrimination and denial of human liberty to disbelievers, such as the Islamic gist, why the fundamentalist and the Islamization, so that as we found due to some due to the impact of Islamization, some countries has become a vehicle to perpetuate hegemony of the ulemas and Khomeinis, like such countries as in Iran, in Pakistan, so also the Gaddafis in Libya, so also we found a very perverted form of independent Khalistan, and that was a result of Savigny's vogue gist. So now we'll discuss Savigny's theory of law, and regarding that, the first one, it is custom as the expression of popular consciousness. He insistence on custom as the expression of popular consciousness is not historical and sociologically correct. Indeed, many customary practices like slavery in ancient Rome developed as it served the interest of the powerful minority, as we found in the context of slavery as it was practiced in the ancient and medieval time in Rome. Similarly, the practice of untouchability in India sustained by Manu and others only to serve the cause of the Brahminical class. So, another part of his theory of law is opposition to legislation and codification. Further, Savigny's concept of law is negative and narrow in outlook and content. His opposition to legislation and codification of law overlook the role of activist modern parliaments in generating new social, secular, and egalitarian values and ideals. Such we found in New Turkey under Kamal Pasha and India under Nehru. So also we found in Savigny's theory another band that is perverted to Nazism, racism, Marxism, and fundamentalism. Another bane of Savigny's vogue is that it has been perverted for dissimilar objects and in support of opposing ideologies like Nazism, Marxism, racism, and fundamentalism. Nazis twisted it by giving it a racial color. The Marxists used it in the form of economic interpretation of history, and the fundamentalists see it a guise of religious resurgence and revivalism, and those forwarded form of racism as it was in practice in South Africa was in a perverted form the racial segregation of the Negroes or the blacks. So, another part of his theory is maintaining the purity of Bogist. Moreover, give and take and imitation has an important place in program of modern industrial and welfare state. This was vehemently opposed by Savigny on the pretext of maintaining the purity of the Vogist, the popular spirit or the popular consciousness. Had the jurists and reformers stuck to Savigny's theory, the world would have been different place, dominated by fatalists, fundamentalists, etc. And finally, it was a divisive force in body politic. Finally, Savigny's Vogist is reappearing as a cancerous divisive force in body politic of several countries like Canada, USA, Ireland, England, Cyprus, Philippines, India, Pakistan, etc. So, for example, out of India, Pakistan was created only on the basis of religion and in turn out of which solely on linguistic reasons Bangladesh came into being. Similarly, the Sikhs of Indian origin residing in US, England, and Canada have been demanding separate identity solely on religious basis, attempted to destroy India's secular, egalitarian, and democratic constitutional polity. In Canada, also a similar situation exists where the Canadians of French origin in Quebec province have been demanding separate statehood solely on linguistic grounds. The demand of Welsh and Scottish people in Great Britain for separate statehood is fostered on the same ethnic and linguistic basis. So, now we'll discuss about the contribution of Savigny. So, in regards to his contribution, we could say that law in terms of popular will or Vosgist is an important contribution of Karl von Savigny to jurisprudence. And also the growth of legal theory is another contribution. And also his theories of Vosgist or popular consciousness led to development of the approaches of men, Henry Men, Rose Compound, Ehrlich, and the Scandinavian realistics. It also led to growth of comparative jurisprudence. So the very theory of interest of Herring and Ehrlich developed due to the influence of Savigny's theory of Vosgist or popular consciousness as true law. So the greatest contribution of Savigny has been that he interpreted jurisprudence and law in terms of people's will, the Vosgist, and thus showed the seeds of modern anthropological and sociological law in relation to society. Indeed, the anthropological approach of Sir Henry Mann, the sociological approach of Roscoe found in the United States of America, the realistic approach or the left wing of sociological school of Scandinavian realists, and finally the sociology of law of Ehrlich are outcome of historical approach adopted by Savigny. So also comparative jurisprudence is another development which has emerged as a result of Savigny's work. He is the first jurist to propound the evolutionary theory of law on the matrix of history and culture, resulting in nationalistic movements and revivalistic movements. The modern pragmatic philosophy is basically rooted in the historical assumptions of Savigny. The modern realists take into consideration the grassroots realities of the people and societies to make law, people oriented depending on their historical, geographical, ethical, and cultural genus or requirements. This is so because of Savigny's dictum that law grows with people and develops with the people. Significance of his contribution can be studied from another aspect too. The positivist had made law so barren, so lifeless, and so useless that it became a curse rather than a cure, providing succor to the people. Savigny's theory of law, unlike Austin, did not castigate morality and social ethos which constitute the main cementing beam of custom and tradition. Further, Hiring and Ehrlich devised their theory of interest on the foundation led by Savigny. It is true he has been responsible for giving a national and racial outlook to law, but his efforts to make law a living and dynamic law also can never be ignored. His theory of law is a powerful social and historical force shaping the destinies of the societies. So, to sum up, his theory of law is revolutionary and an agent of cultural and historical renaissance, and to others it is a destroyer or of racial harmony among people and states, resulting in race discrimination and responsible for World War II, which witnessed unprecedented racial prosecution of Jews, especially. So, while analyzing Karl von Savigny, who is considered as the father of historical school of jurisprudence due to his contribution of Vogist or popular spirit or popular consciousness of the people, which is law. And another important thing he contributed that law is not man made, it is being found and discovered. So he emphasized on the evolution of law and his emphasis on customs and traditions. And as regarding very emphasis of Savigny on the theory of evolution of law like language, grammar, the culture, the folk music and folk dance literature. So, so due to this theory of evolution of law, he is considered as the Darwinist before Darwin, as because in 1861, Karl von Savigny, the late professor of law in Berlin University and who was also the Prussian Minister of Justice, died in 1861, and just before 1 year of his death, Charles Darwin published his monumental work, The Origin of Species, which created the storm in the world, both in science, the biological development and evolution of human species, and also some other animal species. In the same way, long before him, Karl von Savigny discovered his theory of evolution of law, and that's why he is being called as Darwinist before Darwin.